So first, this regulation of hunting. What are the major provisions, or what is the nature of the provisions that regulate hunting in India? Because Wildlife Protection Act 1972, that follows a schedule system. It contains 4 schedules, schedules 1, 2, 3 and 4, and several wildlife species are included in these schedules according to the nature of protection they demand. For example, if some species are really in the verge of extinction, probably a more stringent regulation or control is needed. Probably prohibition of hunting is required as far as that particular animal or plant is concerned. Whereas if some of them are, their population is relatively safe, but if some kind of regulation is not adopted, they might be pushed towards the extinction. In such cases, a lighter level of regulation may be necessary. In that case, this is the logic behind this, having different kind of schedules. And as we move on from schedule 1 to 2 to 3 to 4, the standard or the strength or stringency of the regulation gets diluted. For example, the most stringent regulation or restriction applies in the case of schedule 1 animals. For example, the general rule is hunting of animals included in schedule 1 is prohibited, and this prohibition, however, is not absolute, and this is subject to some exceptions. For example, there are mainly 2 exceptions to this prohibition. That is, if hunting of schedule 1 animal is permitted if that particular animal has become dangerous to human life. 2, if that particular animal is so disabled or diseased as to be beyond recovery. That, as we can see, there are two critical conditions upon which hunting of schedule 1 animal is permitted, and one is if particular animal is dangerous to human life, and 2, the second condition is in the interest of that particular animal, because if that particular animal is so disabled or diseased, and then the possibility of recovery is either nil or extremely less. In that case, these are the 2 extreme situations in which hunting of schedule 1 animal is permitted, and 1 for protecting human life, for 2 in the interest of that particular animal. So that means there's virtually no other situations where the hunting of schedule 1 animal is not permitted under the Wildlife Protection Act 1972. As far as hunting of schedule 2, 3 and 4 animals are concerned, this is more or less similar to what we had just discussed. However, the stringency is slightly diluted. As we can see, hunting of schedule 2, 3 and 4 animals are permitted if there are 3 conditions. At least when compared to schedule 1 animals, there is one more condition has been added, and that is the existing condition is like if animal has become dangerous to human life, that is to protect human life. Then the other is if that particular animal is so sick or diseased and the recovery is not possible, or the chances of recovery is extremely less. The third condition is this is the critical, the dilution part when we compare it to the schedule 1 animals, that is hunting of animal listed in schedule 2, 3 and 4 can also be permitted to protect property. This includes standing crops as well. So that means the relaxation, as you can see, is that it is not just for human life, but it's also hunting of schedule 2, 3 and 4 animal is also permitted for protection of property, that includes crops. And this is in the context where animals, wild animals sometimes pose threat to agriculture or standing crops. So if it is schedule 2 or 3 or 4 animals, and the hunting can be permitted as far as those animals are concerned if such animals pose threat to standing crops. There is another situation in which hunting can be permitted, that is for research and educational purposes. But there are several conditions to be satisfied as far as this issue is concerned. For example, permission of Chief Wildlife Warden is mandatory for permission of hunting for this research and educational purposes. Again, the purposes has been mentioned explicitly in the statute, and this includes, quote unquote, it is education, scientific research, collection of specimens, or if it is for recognized zoos or for museums and similar institutions. And there is a third major condition situation upon which this hunting of animals for research and educational purposes is allowed is if it is for preparation of snake venom for manufacturing of life-saving drugs. So what we can see is, I mean, hunting can be permitted. There are two conditions. It can be permitted only by the chief wildlife warden, and this can be permitted only for certain purposes like scientific research and education, or for preparation of certain medicines like venoms. And if it is Schedule 1 animal, even for research and educational purposes, prior permission from the central government is mandatory, whereas for Schedule 2, 3 and 4 animals, this prior permission from the state government is required. I mean, this shows a kind of stringency as far as Schedule 1 animal when compared to Schedule 2 and 3 and 4 are concerned. For example, as far as Schedule 1 animals are concerned, this the power has been vested with the central government, but whereas other schedules or animals in the other schedules are concerned, prior permission, I mean the power to give prior permission has been vested with the state government. So what we can see is, I mean, as far as Schedule 1 animal is concerned, utmost precaution and screening has been envisaged under the Wildlife Protection Act 1972. But however, there's one issue to be discussed is, I mean, how central government is better than the state government as far as issuing this permit is concerned. Apparently, the Wildlife Protection Act 1972 seems to be following a presumption that, I mean, central government is perhaps the best protector of the interest of wildlife when compared to state government, but there is no empirical evidence to substantiate this. However, I mean, this is one way that Wildlife Protection Act 1972 provides stringent regulation as far as hunting of Schedule 1 animals for research and educational purposes is concerned. And as I had already mentioned that, I mean, Wildlife Protection Act 1972, even though originally it was meant only for animals, I mean, later on through an amendment, plants were also included. But as far as these plants are concerned, this also follows a kind of schedule approach as followed in the case of wild animals. For example, all regulations envisaged under the Wildlife Protection Act 1972 is applicable only to specified plants. Specified plant means plants notified by the central government. So what are the major legal regulations applicable to plants? One is destruction of specified plants. That means destruction of those plants enlisted in the central government notification is prohibited, and trading in those specified plants are also prohibited. That means destruction and trading are prohibited. Apparently it presumes, or it is based upon the premise that, I mean, this destruction and trading, I mean, trading is one of the major reasons why some of these plants are being destroyed. And another major regulation is picking, uprooting and acquisition of against specified plants. In the case of picking, uprooting and acquisition, the regulatory approach is such actions require prior permission from the chief wildlife warden, and this can only be permitted for a certain purposes, that is educational and research and scientific research. Another major substantive part is habitat protection. As we had already mentioned in the beginning, like, I mean, habitat destruction is one of the major threat faced by wildlife in India. So Wildlife Protection Act envisages habitat protection as one of the major goals. And there are, I mean, in the Wildlife Protection Act, the habitat protection has been designed or envisaged as in the form of declaration of sanctuaries, national park, conservation reserve and community reserve. That means there are four kinds of protected areas envisaged under the Wildlife Protection Act 1972. So the critical questions in this context is how these protected areas are determined, who makes the decision, and what are the legal implications whenever there is a decision to declare protected areas, whether it is a sanctuary, national park, conservation reserve or community reserve. So we will discuss these protected areas one by one. First, national parks and sanctuaries. The major criteria for declaring any particular area as a national parks and sanctuary is where if that particular area is so crucial for sustenance of wildlife. So that means the idea behind is to find a natural habitat that is crucial for protection and conservation of wildlife, and then declare that particular area as a protected area. and this power to declare or power to determine and declare such protected areas, I mean power to determine and declare national parks and sanctuaries vests with the state government. So that means the state government has the power to determine if there is a particular natural habitat that is so crucial for wildlife protection and conservation, and then they can declare it as a protected area, that means a national park or a sanctuary under the Wildlife Protection Act 1972. So then the critical question is, what are the legal consequences when they declare a particular area as a national park or a sanctuary? I mean, four major legal regulations that are being applicable in the case of national park and sanctuaries is like restriction of human actions. One of the purposes for declaring a national park or a sanctuary is to restrict human interference in that natural habitat. This is partly because, I mean, human interference or human intervention is one of the major reasons or one of the major threat for wildlife. And the second major thing, a major legal consequence, is prohibition of activities that lead to destruction of wildlife, and it could be like clearing of forest or burning or cultivation, whatever. So, and the third major thing is prohibition of commercial exploitation of natural habitat, that means prohibition of commercial exploitation of that national park or sanctuary. And the declaration or the determination of national park and sanctuary also leads to restriction of several customary rights of for traditional forest dwellers or tribers, which includes grazing and private tenurial rights. So what we can see from these legal regulations is the primary purpose is to detach human beings or insulate the natural habitat of wildlife from human beings. So to put in a different way, to completely prohibit or regulate strictly the human interference or human activity in the natural habitat of wildlife or determined wildlife habitat.